It's great to be back with all of you here in the middle of May, and there is a lot to cover. Certainly, we can talk about the ways in which the FTC continues to reverberate in terms of its non-competes, and we will be doing that shortly with Mark Beloborodov, and we have matters relating to immigration, as well, ERISA, and even with credit card fees and charges on the agenda. So Kathy, why don't I just walk the group through, if you wouldn't mind, please, and I will let everyone know what's ahead. In terms of general updates on the legislative process in New York, what I had decided to do today was essentially to let our other speakers have the floor rather than me, just because we're in a moment in New York State where there is, yes, a lot of end of session activity, and the session concludes really momentarily at the in just the next couple of weeks. However, there's not a tremendous amount of optimism, regardless of position, around much legislation getting passed before the end of session, just because the budget process took as long as it did relative to its April 1st mark, that it is supposed to be concluded by, that the budget didn't get done until much later in April, left lesser time for bills outside of the budget. So we will keep you apprised on those items that seek through as between Kristen and me. But for today, I'm just going to note that is something that will be coming, and you can expect to hear from us on it. But in lieu of that presentation, as I mentioned, Mark, who is with us out of our Boston office and part of our intellectual property team, is going to be looking at the FTC, as I indicated, and the non-compete position, and in particular, how that relates to intellectual property. It's an applied approach that will be, I think, of great interest to many of you, whether or not you work directly in the IP space. Mark always has lively and informative presentations for this group, and we're glad Mark's back with another. John Harris, who is down the hall from me here in New York City and who has been on the webinar certainly a few times before, as I mentioned, is going to be looking at ERISA. There are new standards around fiduciaries that are worth this group's attention. David Bergio, who is new to the webinar out of our Buffalo office, will be talking about those credit card surcharges I alluded to. I think all of you have had the experience of in New York State, noticing that things are a little different when you get to a point of sale, as between cash and credit card, and how that's being handled. The reasons why, and there are also implications for all of you and your businesses that we want to begin to make sure that you're appreciating as these new standards get implemented. And then Liz Heifetz, who's also here from New York City in the other direction, down the hall, is back on the program. We thank Liz for being a regular as well. And for today, making sure that all of you have an appreciation as to what's in store with the Department of Labor and its Form 1089 application. There have been changes there that are relevant to all of your businesses and efforts to bring in individuals from overseas to conduct work. So I will let each of them get into those details more thoroughly, but let me first begin by introducing Mark. As I mentioned, Mark is with us from Boston. He's a member and a key voice in our intellectual property practice. Mark has, among other presentations outside of the Tuesday webinar, been recently in many of our clients' backyards, presenting on artificial intelligence, because that, of course, is an area that has close interconnectedness to IP, and so Mark has been providing voice to some of those issues. But today, Mark is here to talk about, again, looking at this FTC non-compete standard, which Brad Hoppy didn't preview, but walked through with all of you 2 weeks ago, essentially now looking at specific subject areas and what the implications may be. And we're really glad that Mark is available to give us that kind of context. So Mark, please go ahead. The floor is yours, and we're very much glad you're back with us.
Hey, thank you for this kind of introduction. Good to be here. Next slide, please. So indeed, as Kate mentioned, we presented, I think, last seminar in April about this really interesting development with FTC banning non-competes that came as a surprise to many employers. Although in many states, including California, they weren't in use for quite some time. So the world we are going to live in, starting on September 4th, the effective date of the ban is non-competes are no longer available and not going to be enforceable. So the final rule prohibits kind of de facto non-competes, very broad NDA provisions, some sort of financial penalty, and other ways to limit departing employees' ability to compete with their former employer. Exceptions are, of course, during employment, that is possible. For now, senior executives, those kind of in a policy-making, decision-making role, making over 150K annually, they're excluded while their non-competes are in effect, but no new ones. And exception is also non-competes related to the sale of a business. Next. So what are the obligations? Employers must notify all existing and past workers that non-compete will not be enforced against them. Workers defined extremely broad, really anyone the employer ever had in a non-compete with, employees, contractors, interns, really a very broad spectrum of folks who are working with the employer. And there is a amount of language in the rule that satisfies the requirement. Next. So what else, other than acknowledging that non-competes are no longer enforceable, what else should employers be doing now? And this is the focus of my brief talk today, and that is two things. Really take a closer look at their IP strategy, at their IP policies and practices with respect to trade secrets and the decision-making process when it comes to seeking patent protection versus keeping some of the inventions a trade secret. Next slide. So trade secrets are out there, and this is a viable and quite strong kind of an IP right when used as intended, when used properly. And not everything that is of use to an employer, not anything that the departing employee who started competing business and took from the employer could be actually fairly viewed and enforced as a trade secret that was improperly taken. So it's any information that provides advantage in the marketplace, such as formulas, recipes, processes, best practices, know-how. But there are three requirements that you need to establish when enforcing trade secrets. Information that is not generally known, that is valuable, and there are a set of standards of what is valuable means, and then measures have been taken to guard secrecy. And that is not a very easy requirement to meet. You really need to show that you've taken the secrecy seriously and took steps to protect that. So why are we talking about this? Non-competes were agreements that were relatively easy to enforce. Don't compete once you depart. And when you can't compete, you can't use information that you learn. So now there is necessarily going to be a fallback on trade secret option as a way to protect what was valuable and potentially taken by a departing employee. So the good news is trade secrets last indefinitely for as long as secret is maintained. Bad news, you really need to have a good hygiene, if you will, or discipline in your trade secret policy. And remember that when information is developed independently, disclosed inadvertently, or you really cannot establish these three requirements, you may have a difficulty in enforcing trade secrets. Next. The other area to explore here is some inventions. You can go either way. You can kind of keep them as a trade secret and treat them as such and have a policy applied to them, or you can file for patent protection. And of course, you cannot have it both ways. To seek patent protection, you need to disclose how invention works. So the secret protection is forfeited, but for the same product, you can use multiple IP rights kind of attached to it. So protection is complementary. But when both options are really available, you can really go either way. The decision to seek protection really depends on which IP right is more valuable. And one of the important factors here is whether you can actually practically keep secret that information that potentially could be leaving you with your departing employee. How likely it is that it will remain secret. And so that is a factor in perhaps seeking patent protection as a defensive mechanism, anticipating that you won't be able to benefit from the secrecy of that information. Another factor related to this is oftentimes, even when invention is otherwise non-detectable, so it might be difficult to see who is using it. If you protect the information and you know that it's out there, the departing employee might start competing business. It might be used out there. All of a sudden, you have a pool of potential licensees because you actually know who and when might use your proprietary information. Next slide. So practically speaking, and this is what I mentioned before, the challenge is that secret enforcement is more burdensome than relying on non-competes as we could before September 4th this year. And that enforcement requires attention to information control, access management training, and vigilancy, true vigilance in dealing with departing employees. So some steps that I would recommend is take inventory of your trade secrets. Really have a list, have a set of binders. You really know what is in it. What are your jewels that you benefit from them being secret? And then restrict access to them, physically and technologically. Establish need-to-know basis. Restrict physical access to secure areas. Implement state-of-the-art security measures. All this will not only prevent information from leaving, so you didn't disclose it to too many people, essentially, but also will help you enforce if you have to. Next, update and increase your reliance on NDAs. Those are still available. You need to make sure they're not too broad to prevent someone from competing, but it's a good idea to specifically address trade secrets in those NDAs. Next. This bullet point is a big one. Update your handbooks and HR policies and conduct training. Really educate your employees while they're still with you. What are your trade secrets? And manage expectations as to how they should handle them. Really promote the culture of respect for IP rights and importance of IP for your company's success. And then remind departing employees of their obligations when they leave. Many companies kind of skip the exit interview stage, but it's really valuable. The last time you see your potential future competitor, remind them what they know, remind them of their obligations, remind them of what is not okay when they go and do whatever they want to do. In California, where non-competes haven't been in use for years, this worked quite well. And then second step, why they do depart, make sure you know they didn't take anything with them. Conduct an audit, make sure there's nothing unauthorized no information left your servers. And lastly, as I mentioned before, consider seeking more patent protection. Kind of change your metric as to how you decide whether to seek patent protection, go for patent filing, or keep something a trade secret. The notion that you may not be able to keep something a secret should weigh more heavily these days, after September 4th, on your decision to potentially go for patent protection. I think that's the end of my talk. Any questions, be happy to answer now or offline afterwards. Thank you.
Mark, thank you. That was really terrific. And there were a few questions that came in during your chat, and I've encouraged individuals to reach out offline to us because they were generally of the nature that are more individual to participants. But yes, I know that Mark is very happy to be of support in an offline way to any of you following the presentation. And Mark, I thank you for coming back on the program with, as always, really interesting and topical content. And please come on back. Now what I'll do is I'll transition to our next speaker for the afternoon. And that's John Harris, who is, as I noted, seated just a few doors away from me here in New York City. And John has been on the program a couple of times over. And today, what John is going to be addressing are ERISA definitions concerning fiduciaries. There have been some important updates, and we were discussing what would be worthwhile for this audience. And John said, I've got the topic for you. So here we are. And John, I thank you very much. Returning senior counsel here on the program. And please, the floor is yours.
Yes, thank you very much, Gabe, for that introduction. So today we'll be discussing whether you are a fiduciary now after this new DOL rule came out on April 25th, 2024. It's a broad expansion of who is a fiduciary, and we'll be unpacking it during this presentation. So Kathy, if you go to the next slide. So today we'll be going over, first, I would just want to point out the objectives. So I understand that not everyone on this webinar is potentially an ERISA fiduciary, but that doesn't mean that this does not apply is of interest to you. Well, for people who are investment advisors or run a retirement plan or a welfare plan, this is important for you to determine whether you are now considered an ERISA fiduciary, which requires you to do a lot of different things that we'll go over today. But if there's no chance of you even being, let's say you don't manage a retirement plan or you are not an investment advisor, you probably have some savings or some assets that you are investing for retirement. And so this presentation will also inform you of the rights that you have, or at least the service you're entitled to under the new Department of Labor rule on fiduciaries. So this presentation will give you a little bit of background about what this fiduciary rule is, where it came from. We'll go over what the elements are of the new rule, how it's impacting all industries really, and its chance of survival, because there have been legal challenges in the past to these types of rules. And actually on May 2nd, an insurance group filed an action to try and invalidate the rule. So next slide, Kathy. So everything starts for employee benefits really in the 1970s. That's when the Employee Retirement Income Security Act of 1974, also known as ERISA, was enacted. And it did two things. Number one, it established, it did a lot of things, but for this presentation, it did two relevant things. Number one, establishing fiduciary duty. So anyone that manages a retirement plan for an employer or a welfare plan, like a healthcare plan for an employer, you're managing an ERISA plan. And as part of that management, you are considered to be a fiduciary. And as a result, you have a duty of loyalty to the plan, a duty of prudent management and prudent investment of its assets. You have to operate that plan in the best interest of participants, and you have to avoid any conflicts of interest. That includes some sort of financial incentives. So for example, if you're an investment advisor, advising a retirement plan on investing in a particular mutual fund, but at the same time you're getting commissions from that mutual fund, that could be a breach of fiduciary duty. And ERISA also defined what a fiduciary is. And there are two types of, broadly speaking, there are two types of fiduciaries under ERISA. The first is a person who has discretionary authority over the assets or administration of a retirement plan or welfare plan. The second type, which is going to be the focus of this presentation today, is anyone who renders investment advice for a fee, either directly or indirectly, with respect to a retirement plan asset, for example. And these are known as investment advice fiduciaries. Next slide, please. And this concept of an investment advice fiduciary was a little bit vague in the statute. So the United States Department of Labor in 1975 issued a regulation that defined more specifically what an investment advice fiduciary was. And there's a 5-part test to it. It's someone who renders advice as to the value of securities or makes a recommendation about the advisability of investing in securities or other property on a regular basis pursuant to a mutual agreement to a plan or plan fiduciary that serves as the primary basis for investment decisions and that is particularized to the specific plan. So to put a gloss on that, this test really only made people who were regularly advising an employer-sponsored pension plan regularly pursuant to an express written agreement that delineated the terms of the advising. And the only time it applied was with the pension plan actually relied on that advice in the investment decision. So it was a relatively focused set of people that this 1975 rule applied to. If I get the next slide, please. Now, from 1975 to 2024, that's the rule that stayed the same for the whole time. But at the same time, there were some major qualitative changes in the investment environment during that same time period. I have 3 points of data here that just give you a little snapshot about the change. So in 1975, defined benefit plans, which is like a pension plan, held 71% of retirement assets, while defined contribution plans, like a 401k, held 29% of retirement plan assets. The pension plan assets, when you have a pension plan, the individual investor bears no investment risk. They're always going to get their defined benefit. Their whatever $500 a month, whatever it is after retirement, they are going to get that. It's the plan sponsor, the person who's running the pension plan, that bears the investment risk in a defined benefit plan. So in 1975, individual investors did not really bear a lot of individual risk. But then you see in 1983, only 62% are covered by pension plans. And now the most recent stat I could find was 2007, only 17% of workers are covered by a pension plan. And so that means that a lot more people are out there kind of investing on their own for retirement. Kathy, if I get the next slide, please. So I created this little bar graph to kind of drive home the change in the investment environment. So the blue column are pension plan coverage. So in 1975, you got 70% coverage of the market share of retirement plan assets / covering retirement plan participants. 83, it starts to go down, but as you can tell, in 2007, it entirely flips. It's almost all now defined contribution plans, and I would suspect that if we had a graph up to date, 2024, it's even higher, probably closer to 85% coverage of the entire market in defined contribution plans. So if I could get the next slide, Kathy. So because there was this change in the investment environment, there started to be some ideas about changing the 1975 rule. And that change came from a couple of different policy ideas. The first is to protect retirement investors. And I kind of already touched on this, but today it's the individuals that are managing their 401k investments or their individual retirement account investments, as opposed to sophisticated pension fund administrators that have a litany of advisors to make sure that they are getting the best fiduciary duty compliant investments for their plan participants. So as a little snapshot, in 2022, Americans rolled over $779 billion from their 401ks sponsored by employers to an individual retirement account. So that means that this 779 billion is now just solely being managed by individuals, unlike, the Charles Schwab account or Fidelity account, something like that. And people in Washington, D.C. are now thinking that based on this, we're thinking we need to give individual investors more protection than what the 1975 rule provides, because it's really only limited to regular advice and pursuant to an express agreement with a plan as opposed to individuals. The second policy driving this was closing loopholes in the 1975 rule. Biden administration identified 3 blind spots that the 1975 rule does not cover, including one-time financial advice over transactions like a 401k rollover, which is what I just described. It's these people who rolled over the $779 billion into an IRA. Well, that's a one-time transaction that wouldn't meet the regularly advising condition of the 1975 rule for fiduciary duty rules to apply. So potentially, whoever advises you on the rollover could have these conflicts of interest that are not prohibited by the definition of an investment advice fiduciary. So that's supposed to be closed. They want to close that. They also want to close the fact that certain non-securities are not covered, especially this product called fixed index annuities that insurance companies offer. There was a focus on that. And also, they wanted to make sure that fiduciary duties apply to recommendations concerning 401k lineups, meaning what investment options do you see as potential mutual funds to invest in with your 401k? So they wanted to have fiduciary duty cover those things. And that was kind of driving this transition to, and next slide, please, Kathy, to this new rule, which was, it's hot off the press, April 25th, 2024, became a final rule. And it's a broader definition of an investment advice fiduciary. So it's anyone that makes any sort of investment recommendations concerning any sort of investment transaction or any investment property. So it's a much broader first element than the 1975 rule. To a retirement investor, and I have the definitions that listed on the right-hand side of the slide here. And you can see that they're much more expansive than just an ERISA plan. It's also an IRA owner. So it's much broader as to who is the recipient of advice, this applies to. Someone who does this recommendations to investment advisors for a fee, and the person and there are 2 elements here, but basically the import of these elements is that the person is making the recommendation in a context where they are engendering trust and confidence on a reasonable investor basis standard. So in the prior rule, it was that there had to be actual evidence that the plan made an investment decision based on the investment advisor's advice. Here, it's not that it has to be an actual evidence of it. There just have to be an indication that a reasonable investor would have believed that the offer was particularized to his or her needs, and that the person is affiliated with a business that regularly makes investment recommendations. So again, that's a much broader scope than the 1975 rule. Next slide, please. So the impact of this new rule is that we're closing the one-time advice loophole of the 1975 rule. And it used to be that you had to regularly provide investment advice to be considered a fiduciary, but now there is no such regular advice requirement. Any person can become a fiduciary if they provide a recommendation in a matter that, in a context that establishes trust and confidence with the investor based on the facts and circumstances of the test. it eliminates the mutual agreement condition. In 1975, you could only have a fiduciary relationship pursuant to an agreement. Here, you don't have to have an actual written agreement or some sort of understanding. It's based on, again, the facts and circumstances in which the recommendation is being made. Next slide, please. Also, the new rule explicitly says that you cannot, an investment company, the advising company or brokerage company or insurance company, anyone that's making these recommendations cannot disclaim their fiduciary status in a written statement. You know, sometimes you'd see footnote 4 in the fine print, size 8 font. We are not a fiduciary. Do not rely on us as fiduciaries. Well, that's a nullity under this new rule, and so investment advisors and have to realize that they could be fiduciaries, notwithstanding written disclaimers. So as a result of this, a lot more people are going to be considered a fiduciary under ERISA, and that requires them to have that duty of loyalty, to avoid conflicts of interests, and to act in the best interest of the participant or the person they're advising. Otherwise, they could get subject to a lawsuit and ultimately have to pay damages under ERISA if the recommendation was not in the best interest of the person receiving that advice. And conversely, people who are not investment advisors but who are getting the advice, this is good for you to know, so that if, hopefully not, but if it does happen, you have these rights. And so, next slide, please. The final slide here is whether this rule, though, is going to survive, because there have been past attempts to do it. They have failed in the past, but this time is the first time they've gotten the final rule passed, and the DOL is hopeful this will stick. But on May 2nd, a mere 7 days after it was introduced, there was a new federal lawsuit filed to nullify this new rule, and we'll be monitoring it. But in the meantime, we recommend reviewing your materials and training your staff to comply with the new rule. But we're here to help you out with that.
John, thank you. Really interesting material. And as you point out, it is timely. We'll see whether that lawsuit sticks and slows anything down, but these are major changes. And so it is important that this group has heard about them from you. So thank you again for coming on the program. Let me shift to our next speaker for the afternoon, who's David Bergio. And David is coming to us from our Buffalo office. David is here to discuss what all of you, I would assume one way or the other, have encountered. There have been changes in New York State with regard to how credit card transactions are being handled and disclosed, essentially. And this is something that started a few months ago, but we're seeing in the rollout some interesting trends, and we thought further that this would be a good time to bring all of you up to speed, and as businesses to be particularly on the lookout for certain aspects of what enforcement looks like. So, David has been doing some background research on all of this and is here to share what he knows. David is, as I mentioned, an associate with us and on the program for the first time. We're really glad to have you, David. Welcome, and please educate us.
Hey, thank you, Gabe. I appreciate it. So like Gabe said, I'm David Bergio, and we'll jump right in. So, many of you are probably familiar with what exactly a surcharge is. But for those who aren't, a surcharge is a fee that merchants or business owners will charge the customer. And the purpose of that is to kind of recoup some of those processing fees that the major credit card companies are charging in order for businesses to use their card as a payment method. And again, with those charges, we have Visa, MasterCard, American Express, all charging merchants and service providers between 2 and 4% of the total transaction on average just to process payments using their card. So again, it's very important for the business to be able to recoup some of those charges. And I do want to point out, so obviously the name surcharge isn't exactly the focus point here. Whether you call it a surcharge, a processing fee, a convenience fee, additional fees, so on and so forth. If the business is putting that charge back onto the customer to recoup some of those charges based on those processing fees, this law is gonna very likely apply. So, just by way of background, surcharging in New York State has always been governed by General Business Law 518, and this is going to be a pure consumer protection law. So it's focused on the consumer, focused on consumer protection. And when adopted originally, it created a total ban on credit card surcharges. So in the state of New York, you weren't able to really recoup some of those charges. And luckily, in 2018, we had a Court of Appeals decision that came in Expressions Hair versus Schneiderman. And basically it said that General Business Law 518 should be more interpreted as a disclosure law instead of a total ban on the surcharge itself. So, this was a big win for merchants and service providers alike. But unfortunately, the legislation didn't exactly catch up with that decision. So we had the court saying one thing, we had the statute say another thing, and it really wasn't meshing well. So it took about 5 years, but that brings us to December of 2023. Governor Hochul passed an assembly bill, and that bill amended the language of 518, and it's going to be more consistent now with the interpretation from the Court of Appeals. And basically, what this says is businesses do have the option now to pass along those processing fees through surcharges to the customer, so long as there's a transparency there and businesses are disclosing before the point of sale. So, if you can imagine, you're at the grocery store, when you're taking something off the shelf, the highest price for that item, including the surcharge, but not including sales tax, is going to have to be displayed in one way or another. And there's a few different ways to get that disclosure out that we will go over. But again, so this bill was introduced for the consumer. And the goals here are to kind of take the calculation of how much am I actually going to be paying for this good or service out of the hand of the consumer or the customer, and make them aware of the actual price upfront, not just when they're ready to pay, not just at that point of sale, whether it's online or, at a classic cash register, et cetera. So, again, good for consumers because we have that protection, good for businesses because we're finally able to recoup some of those charges. But unfortunately, as does happen, there's a bit of a delay in the law, and New York kind of dreamt up this statute with the consumer context in mind. So again, you go into a store, you buy an item, the price is right there. They didn't take full consideration into the fact that, a lot of transactions are very complex. We have, tuition bills, we have manufacturing orders with various items that are being purchased, contractor, all these multi-level sales weren't exactly the main focus of this statute. But through some conversations that me and some other colleagues at the firm have had with the Office of the Attorney General, we have confirmed that these laws apply to merchants who deal in consumer goods, service providers, pretty much anything in that spectrum of sales. This is gonna apply to. And unfortunately, to this point, we are 3 months out. This bill has been effective since February. There hasn't been a whole lot of guidance from the state on these complex transactions, especially. But we do have some understanding because the law has laid out some of the acceptable practices and how we can reach compliance. So some of these things that you can do to be compliant is to clearly display both a total credit card price and a total cash price. And this is called the two-tier system. So, in a very simple terms, you have a bag of chips. It's going to be $3 if you pay credit card. It's going to be $2.50, for example, if you pay cash. You also have the option of listing the higher credit card price and then a general disclaimer around the store, sort of indicating that there's some sort of discount if you pay with cash. So again, you have a $100 item. You are allowed to post around the store, 3% discount for all cash purchases. The last option you have is to charge the same amount of money for credit cards and for cash purchases. This may be the simplest option as far as not having two prices, not having two different types of things to account for. But there is some risk there with raising prices generally, and people who are paying cash are paying more than the actual sales price itself. So all of these options aren't perfect. There's different risks and steps to doing each of these, but those are the three main ways that New York State has kind of identified businesses can be compliant. So there's kind of a laundry list here of things that businesses cannot do. So first, you can't post a general indicator, such as a sign on the wall or a general disclaimer on an invoice saying, hey, there will be a fee if you pay with credit card of 3%. Now, you may remember I just said that you can do it for the other side, that you can post that there's a general disclaimer that there'll be a discount, but you can't post that there's going to be an additional fee of 3% generally. And the reason, again, is they want to take that calculation out of the hands of the consumer. They don't really care if the consumer gets charged less than they expected, but they do care if they're getting charged more than they expected. So that general disclaimer is not going to be acceptable under the law. You also can't indicate on a receipt a separate line item saying, hey, there's this fee that's associated, because they want the consumer to have that option before they get to that payment terminal, whether they want to pay in cash or pay in credit and pay a little bit more. Further, you can't advertise prices that include certain discounts that don't apply to credit card surcharges. And then again, that fee can't be more than you are getting charged by your processor. So if you have a 2.5% fee with your processor, you can't charge a surcharge that is more than that. And again, there can't be a percentage. It has to be an actual amount of money that is being charged, and it has to be laid out. So a general percentage will not work here. So those are the acceptable practices versus the non-acceptable practices. And just until further guidance is given by the state, which hopefully will be soon, we're just kind of suggesting that clients are compliant with the law as it's written on its face. And again, this is important because there is a $500 penalty for violation that is reported to the Consumer Protection Agency. They will not be investigating directly. It will take some sort of report to get to that point. But again, compliance is key. So if you have any questions or need any help with compliance, we'd be happy to assist. Thank you.
David, thank you. This is a presentation that has generated a lot of traffic in the chat. So I think that's suggestive of the fact that many of those on the webinar are grappling with, what does this mean for me and for my business? And I can tell you that David is ready to help out and will answer as many as possible through the chat. And certainly all of you can reach out to David at the email address displayed here on the slide. Now let's move to our final presentation for the afternoon. That's going to be Liz Heifetz, who is back with us on the webinar. As I mentioned, also here in New York City with us, an associate who focuses on immigration, as well with a large pro bono practice. And today we're here to talk about this new form ETA 9089. What does that mean, Liz?
Thanks, Gabe. Good morning, afternoon, actually, at this point, I think. So today I wanted to talk a little bit about the takeaways from this Form 9089, which you may know as the PERM application form. Just as a, as a review in case you aren't familiar or you just don't remember the terminology of it. So this is the part of the green card process. This is the last step of the PERM labor certification process for the green card route for those individuals pursuing an EB2 or EB3 category. A lot of employers will use this route to get the foreign nationals that they're temporarily hiring, to bring on, for a short period of time to keep them on permanently. And this is the process to essentially get them there. The Form 9089 is the PERM application that is pending for 12 months. Is testing the U.S. labor market. It's the final step. And recently, over the last few months, the form has been updated to a completely new system. Substantively, very little has changed. However, very important little details that pop up on this form are important. And I just, the purpose of this presentation, I wanted to kind of give you some takeaways from that. So when you're filling it out, an agent of yours is filling it out, just so you understand what it is you need to look out for when you kind of, start this process. Kathy, can we go to the first slide? Okay, so one of the first things, as I mentioned, is no substantive changes have occurred. Everything is, substantively what a perm is, what the minimum requirements are. All of that will remain the same. No decisions are being, changed, any BALCA decisions, none of that. So all of that, just mind you that nothing has changed. So there was a lot of, hesitation when this new form came out, and people were scared that none of that is changing. You just have to know how to properly respond to the new questions that are being asked. Just, a quick takeaway also, there's a lot of warnings in the system now. Don't, no panicking need be happening. It's okay. You can continue through it. Just read it very, very carefully. This does not mean your answer is wrong or that something is inaccurate. This is just the tech kind of, we're walking and, working through the system and making sure it ends up becoming a reasonable product. So hopefully by 2025, I would suspect that, we're finally going to get, a very solid system. Right now, we're just kind of tweaking it. Another takeaway is this applies to less individuals, but the Labor Certification Office has made available a final determination version for Form I-140s for Schedule 1 and National Interest Waiver petitions. These are ones that obviously do not require the actual submission of the perm, but they require the completion thereof, and there's special requirements in that form that you need to be aware of when you fill it out. And just as a disclaimer, there will be case specific things that are relevant to your specific employee and foreign workers. So if there's something like that pops up, feel free to reach out and we can kind of discuss how to go about that. But this is just the general overview of what to kind of expect. Can we go to the next slide, Kathy? So this is a good one because now with this new form, no separate attorney employer account is necessary. Their employers, you'll no longer be receiving a sponsorship verification questionnaire at the end. In the old system, it was not a very great system. If you recall, there was a lot of password issues. There's a reason we shifted to the new system. And so in this new system, if the employer wants to see certain information, you would have to reach out to the agent filing for it. And you no longer have to follow up on any questions after the form has been completed, because that just, it causes unnecessary delays, and then they give you a limited time in the past to fill it out. So this is actually a good kind of thing that pops up. And I guess with that, takeaway number 5 kind of flows into that is the legacy perm system. So any perm that was filed before June of 2023 is still in that system. Anything that was filed is still there because as we know now, perm processing times are about 12 plus months. So anything that is there, it's still active. You're going to get an email notification. You do not need to log back in to be able to respond to it. And anything subsequent to June 2023, you should be doing in the new system. All of these things that are popping up, these issues, these takeaways, this is as a result of overseeing and watching what has happened with this new perm system and explaining what to look out for now. Because now we're getting to that point where some perms are coming back to us, and now we understand where the audits are coming from, where the issues were in the new filing. So this is, and we're going to get more of these updates in the next few months, I suspect. And similarly, again, there's a tech help desk, which again, it's probably not the most helpful tech help desk in the world, but they do help with specific technical issues when it comes to the flag system, especially when you're trying to make sure the prevailing wages are properly uploaded and then they match the new perm labor certification. All those things are going to be very, very important. Kathy, can we go to the next slide? So this one is, again, this is more for employers who have attorneys representing them and about how to properly respond to the question. It was phrased very differently in the old system. In the new system, it is phrased with an implication of a fine fiduciary duty, which there is not one. We can discuss that if that comes up. Don't want to spend too much time kind of going into the weeds of this. Just something to note that, and just think about obviously The Office of Labor Certification says commented that this question concerns whether the employee is receiving payment of any kind for obtaining labor certification. This is a no-no in perm labor certification world. So again, just reiterating the fact that this does not actually mean that. It's just something to be aware of and how to respond to this particular question. For takeaway 8, another one. So this is, I specifically laid out where to find this question on the form when you're doing it. This is about knowing how to properly link prevailing wages. In the past, we'd never had to link them. We had to rewrite the minimum requirements specifically with, Kellogg language, which we'll get into in another bullet point. This is just explaining how to kind of deal with those. You have to post annual wages. Now, hourlies do not work. If there's an hourly wage that you are paying an employee, you have to do the math and transfer it to an annual wage. They don't accept hourlies anymore. And they still have to be able to meet those requirements. Obviously, if there's 2 different wages, you have to take the higher wage. And as you two probably know, if there's a hybrid model with employees working in 2, you have to essentially submit both of them. The prevailing wages will come back and you have to pay the higher of the 2, but only at the time of the perm filing, at the time it comes time to adjust status for the individual. So just something to bear in mind there. Kathy, can we go to the next slide? I'm gonna try to, there we go, okay. Again, all of these I'm just brief because I don't want to keep you long. It's lunchtime for people also as well, but things to keep in mind. Again, another one, familiarize yourself with these memo principles. They're going to be very, very important. If you want extra information, I can send them to you. This is just if a work site is unknown, you just have to be mindful of how to properly work on that and put that into the form. All work sites, MSAs, the metropolitan statistical area have to be listed there. Even if it's the same, you may think it's the same state. If it's a different county or something, you might have a different wage. All of that needs to be included. Special telecommuting language must be included. Otherwise it will get denied. As you probably know, perm audits, they're very random. You don't know which ones are going to get audited throughout the year. What you only can do is to avoid red flag audits, such as, not properly incorporating telecommuting and recruitment and so on and so forth. Kellogg language is another great example of that. Firms have been denied for this. This is essentially just telling you that once you're submitting minimum requirements for an employee and the employee only meets the requirements based on an alternative set of requirements, you have to incorporate the Kellogg language, which essentially just says that the employer will accept a suitable combination of education, experience, and training. And that language has to be included in order for this to properly kind of go through all lines. Kathy, go to the next slide real quick. Again, some just more details on, kind of what to look out for. You still need to do physical posting notices, absolutely necessary. They will come back to you if you do not do that and can't show that. Also, foreign worker education. This is a big one. Even if it's not related to education requirements, on the new form, they really want you to talk about it. It can be confusing based on several firms that have been recently submitted because they want you to only put in the education that matches the minimum requirements, even if a foreign worker may have 6 or 7 additional degrees. Our take is you should still incorporate all of them because if you do not, they will still potentially issue an audit to try and just because they just do this now. So just as a practice memo, just make sure to include it all. Get the trust board evaluation for it if you need to. They'll take care of it there. And foreign worker experience, again, this is more of a technical glitch, but essentially technical glitches can come back and bite us later is because you can't even put on the full dates. In the past, you were able to put on full dates and each specific, employment period is important to the day when you calculate the years. You can't do this anymore on this new site. So you have to find ways around it. You should input dates and the tech team is working on this, but that doesn't mean your firm won't get audited. You just have to be careful with that. I think that's it. Just wanted to, Kathy, I think that's it from my end, but if you have any questions on anything else, please feel free to reach out. This is going to be very, predominantly case specific to your individual and your employee and worker, and we can go over that whenever you need to. But this is just the general takeaway to be mindful of.
Liz, thank you. That's really useful technical guidance for all of those who may be encountering the standard and needing to pay attention to what's changed. I know we're running a bit over today, but we thank you for your patience. Let me just quickly remind all of you that there are the workforce forums still taking place across New York State. I will be personally presenting at the Westchester, New York City Forum, so I'll see some of you there. And next week on Tuesday, you'll be with Kristen Smith. If you have any questions for any of today's presenters, their contact information is on the slide presently. I'll be back with you on the 28th, right after the Memorial Day weekend. So I'm hopeful that all of you can enjoy that, get a little bit of rest, and looking forward to closing out May with all of you. In the meanwhile, wishing you a great afternoon.